Well, yesterday's Republican primary had what has become the standard vote split of 63% to 33%. But this time, Nikki Haley got the 63% and Donald Trump got the 33%. It was in the smallest Republican primary so far. It was in Washington, D.C., where in a city of 700,000 people, exactly 676 of them voted for Donald Trump. The reason that tiny vote is significant is that Donald Trump's jury pool for Special Prosecutor Jack Smith's case against Donald Trump for alleged crimes leading up to and on January 6th will be taken. That jury pool will be taken from those 700,000 people who spent yesterday not voting for Donald Trump. The odds of one of the 676 Republicans who did vote for Donald Trump in Washington, D.C. yesterday ending up on his jury there are worse than your odds with any lottery ticket you could buy anywhere. The most important Washington, D.C. voters for Donald Trump, though, are, of course, the 9 voters on the United States Supreme Court. And today, all 9 of them agreed that Donald Trump, who 3 of the justices called an oath-breaking insurrectionist, cannot be barred from presidential ballots by individual states on the basis of Section 3 of the 14th Amendment. And Section 3 of the 14th Amendment, as most of you know by now, bars anyone who took an oath of office and then engaged in insurrection from ever holding office again. Donald Trump's lawyers lost on several arguments that they presented to the court. They argued that the presidency is not an office. The Supreme Court ignored that argument. The Trump lawyers argued that the president is not an officer of the government. The Supreme Court ignored that argument. And most importantly, the Trump lawyers argued that Donald Trump did not engage in insurrection and that the attack on the Capitol was not an insurrection. The Supreme Court ignored that argument and left standing the finding by the Colorado Supreme Court that Donald Trump did indeed engage in insurrection. The Supreme Court's opinion simply said that the individual states are not allowed to enforce the provisions of Section 3 of the 14th Amendment against candidates for federal office. The opinion said that the state of Colorado could enforce Section 3 of the 14th Amendment against candidates seeking state and local offices in Colorado. The 5 Republican men on the Supreme Court, 2 of whom were appointed by Donald Trump, extended their majority opinion far beyond what the 9 justices were willing to agree on in the essential ruling by indicating that even the federal enforcement of Section 3 of the 14th Amendment would require the Congress to pass implementing legislation. The 3 justices of the Supreme Court appointed by President Obama and President Biden wrote a separate opinion of only 6 pages where they referred to Donald Trump as an oath-breaking insurrectionist 4 times and said, quote, legislation of any kind, however, is not required, and that Section 3 of the 14th Amendment is self-executing, meaning that it does not depend on implementing legislation. The 3 concurring justices, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, said, quote, Section 3 provides that when an oath-breaking insurrectionist is disqualified, Congress may, by a vote of 2/3 of each House, remove such disability. It is hard to understand why the Constitution would require a congressional supermajority to remove a disqualification if a simple majority could nullify Section 3's operation by repealing or declining to pass implementing legislation. It's worse than they know. It would not take a simple majority to decline to pass implementing legislation, to vote against implementing legislation. It would only take 41 out of 100 senators to block implementing legislation, which, according to the procedural rules of the United States Senate, requires a 60-vote majority threshold to pass. So, if a group of 59 senators agreed on implementing legislation tomorrow for Section 3 of the 14th Amendment, it could not become law. It could be blocked by 41 senators who support an oath-breaking insurrection and want to see an oath-breaking insurrectionist become president again. There are now 49 Republican senators, and only one of them, the retiring Mitt Romney, has said he is opposed to the oath-breaking insurrectionist Donald Trump becoming president again. That leaves 48 Republican senators who would refuse to ever approve any implementing legislation for Section 3 of the 14th Amendment. The last judge appointed to the court by Donald Trump, Amy Coney Barrett, wrote her own one-paragraph concurring opinion saying simply, "I agree that states lack the power to enforce Section 3 against presidential candidates. That principle is sufficient to resolve this case, and I would decide no more than that." Justice Barrett then added a second paragraph to her one-page concurrence that did not have a single word of jurisprudence in it. It was a political speech aimed at the three other justices who agreed with her that the majority of 5 on the Supreme Court went too far in their opinion. Justice Barrett, though she apparently agrees with those 3 justices, decided for political purposes that their language was too harsh. And that is a political choice, not a jurisprudential choice. In a political statement, unlike any that I've ever seen in a Supreme Court opinion, Justice Barrett wrote, "In my judgment, this is not the time to amplify disagreement with stridency." In her view, no doubt, stridency means using phrases like an oath-breaking insurrectionist to describe Donald Trump. Justice Barrett continued, "The court has settled a politically charged issue in the volatile season of a presidential election, particularly in this circumstances. Writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home." Written not like a Supreme Court justice, but like a political speechwriter. The message Americans should take home. Justice Sotomayor, Justice Kagan, and Justice Jackson highlighted the wild inconsistency of the Roberts Court by quoting Chief Justice Roberts himself, who wrote this when he joined the majority opinion in overturning Roe v. Wade, quote, "If it is not necessary to decide more to dispose of a case, then it is necessary not to decide more." The 3 justices then said, "That fundamental principle of judicial restraint is practically as old as our republic. Yet, the court continues on to resolve questions not before us. In a sensitive case, crying out for judicial restraint, it abandons that course. Today, the majority goes beyond the necessities of this case to limit how Section 3 can bar an oath-breaking insurrectionist from becoming president. Although we agree that Colorado cannot enforce Section 3, we protest the majority's effort to use this case to define the limits of federal enforcement of that provision, because we would decide only the issue before us. We concur only in the judgment." And today, at the Florida club, where Donald Trump cannot afford to live without charging other people money to use his home, the oath-breaking insurrectionist thanked the Supreme Court for their opinion and then spent most of his time asking the court for another favor, to grant him total immunity for any form of criminal prosecution for crimes that he may have committed while he was president. In fact, most of his statement was begging for that criminal immunity. He did say this about today's opinion.
Frankly, they worked very quickly on something that will be spoken about 100 years from now and 200 years from now. Extremely important.
Well, he's absolutely right about that. It will be spoken of in history classrooms 100 years from now and 200 years from now, where he will, if the country remains lucky for the next couple of centuries, be identified as the only former president in history who was once blocked from presidential ballots by states invoking Section 3 of the 14th Amendment. And those history classes will all note that the Supreme Court opinion that allowed him access to the ballot repeatedly referred to him as an oath-breaking insurrectionist.